Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number TX16-0009, Arizona Public Service Company versus the City of San Luis. Council, as I'm sure both of you know, we are recording today's proceedings, both audio and video recording. So when you step to the podium, if you would, please identify yourself and your client. Each side has 20 minutes for argument, and Mr. Irvin, you will be responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs and we've conferenced the case prior to argument. One other housekeeping matter. After 14 years of service on our court, Judge Kessler is retiring later this month, and this is in fact his last oral argument. So please make it a good one. Mr. Irvin.
It's up to you.
Make my day, Mr. Irvin.
It's a high bar. May it please the court, Patrick Irvin for the City of San Luis. At council table with me is Emily Ward. And congratulations, Judge Kessler, and good luck in your retirement.
Thank you.
It seems like a legal cliche to say ignorance of the law is no defense, but this court actually addresses this issue fairly regularly, and as recently as October described that as a well-settled principle in the Elks case. This case has a lot of issues, but the root issue really is that APS knew that the City of San Luis amended its tax code, which applied to it, and it didn't bother to actually read the amendment. It knew by number and by adoption date and by effective date that an ordinance had been adopted, but didn't bother to read it.
Can I
Counsel, go ahead.
We're probably going to ask the same question. I'll ask and see if it's his question as well. Do we know from the record whether, we know that the city sent ADOR an email that attached the ordinance. We also know that ADOR sent notice of the ordinance generally to taxpayers. Do we know whether ADOR attached the ordinance to the email it sent to taxpayers?
We know that APS has conceded that they received it and relied on it.
Really received what?
The
Can you
notice.
be real specific.
They received the notice that DOR issued in April of 2008.
But didn't that notice simply say, my understanding, my read, is that San Luis provided a copy of the ordinance to ADOR. San Luis advised we're raising the tax percentage from 3.5 to 4. Then ADOR sent out a letter simply saying, or a communication, email, whatever it was, saying that San Luis had raised the tax rate from 3.5 to 4%. And citing to 253, I think, whatever the statute number is, or the ordinance number, excuse me. But did they reference anything other than the fact that this is the ordinance that was passed and this is what it said, 3.5 to 4%?
The city sent DOR a complete copy of the ordinance, so DOR had it. DOR, from that information, sent out its notice. The notice only referred to the increase in rates on 16 different classifications of taxation. It also had a provision about that the change does not apply to existing contracts. But the notice is informational. The notice is not intended to be a complete recitation of everything that's in the ordinance.
But your argument would be even stronger if they had attached the ordinance. And I was just trying to ascertain that one point. But there's no indication in the record that the email was or that the ordinance was actually attached to DOR's communication to taxpayers.
I think the answer to that is no.
Okay.
The notice goes out. It's a summary of, here's something you should be aware of. The tax rates increased. San Luis adopted an ordinance. Here's the number. Here's the effective date. Right. It's similar to when the Arizona Attorney Magazine publishes blurbs about this court's decision. It doesn't go into enormous detail. All it does is say there was a decision. Here's the main issue that we think of. I don't think I can rely on that and quote that as this is all the court decided in this case. The law, if anything, requires people to actually read it. To the extent there are exceptions to that, they're very narrow. And I have not found any case that said you don't actually have to read a law that you're aware of. The cases cited by APS, most of them very old, address situations where incorrect information was put in official publications. Here, there was no official publication. That's where the trial court went wrong.
There was a tax code, right?
Yeah.
The tax code was an official document, wasn't it?
We have to be careful about our terms there.
Okay.
The Model City Tax Code is in many ways like a uniform act or a model act, which is sent out for states to adopt.
Right.
But the actual law is what the specific city adopts.
But if the city puts out, has an official publication that says this is the tax code, right? And if APS had looked at that, I just want to make sure I've got this fact right. If I'm ATS and I look at that after the passage of the ordinance, that doesn't reflect what the ordinance did, right?
Well, the tax code, to the extent it's like state Arizona revised statutes, it's not necessarily updated every time there's an amendment.
I understand that, but if
And so there may be time lags, and that's why even the model city, to the extent the legal cities and towns published information, it said to be accurate, you need to call the city, you need to contact them and get it.
But
There's no dispute that APS never contacted the city to ask what their tax code was or to ask about the ordinance.
But this went on for a number of years, right? That the tax code, the city never said, here's our tax code, we've now updated it to show this ordinance. Because the ordinance passed, in 2000.
In December of 2007, effective 2008.
And as of at least, as I understood it, as of at least 2012, the tax code still didn't reflect that change.
That's not true.
Okay, when did the tax code reflect the change?
We don't know exactly when a codified version reflected the change. The only version in the record during the audit period was the version sent by the city of San Luis to the Department of Revenue on July 3rd, 2012, which was when the Department of Revenue was taking over or was assigned by the legislature to keep an official version on their website. So the city went to great lengths to make sure that DOR had accurate information because of it. But there's nothing in the record about the interim between 2008 and 2012 as to when it was codified. What's clear in the record is that APS never asked to read it. APS never asked for the ordinance. APS never asked the city clerk for a copy of the tax code during the audit period. So to the extent it wasn't modified, APS didn't rely on it. APS can't really claim that they were given incorrect information.
Counsel, go ahead.
So if I look at the United States Code, and I say, oh, look, here's an updated version of the United States Code, and it shows all the dates of amendment, do I have a duty to then go back and look at all those bills to make sure the codification was incorporated? Or the amendment was incorporated?
I think the due process clause says yes. And if you read the Torres case, which is cited by the Soltero case, which this court decided and quoted with approval, Torres involved a change to a appeal deadline for immigration cases. It reduced it from 90 days to 30 days. And somebody did research. They actually looked things up, tried to find, and they didn't find the amendment. It was buried in a 2,000-page piece of legislation. The court acknowledged that it was not easily findable. The court acknowledged that they acted in good faith, but it still said the law is the law. There is no due process right to receive individual notice of it, of the change in the law. And in Torres, the court actually said, if it's a problem, it's a duty of the bar and industry to ask for faster publications.
Right, but again, I mean, there's different saying, I think it's slightly different. I'm not saying that every taxpayer or every citizen has a right to individualized notice of a change in a statute. But it seems to me they do have a right to say, I'm looking at the official publication of the United States government, the United States Code, however it's, or at least it's authorized to be relied on, and it says amended. It's current through June 14th, 2017, and it shows the amendments. Do I have and my question really is then, do I have a duty to go back and check each of those, each amendment to make sure that that what I'm reading is accurate? Or do I have a right to rely on what I see in the code?
I think it may depend on how official it is. I don't know if USCA is official or USCS are official. I think the U.S. government would probably take the position that the STAT periods are the only thing that's official. Here, there's no question that APS never looked at anything that was official from San Luis.
And at the time, what was official?
I think the ordinance was official. The ordinance amended the tax code.
But was the city clerk the official repository in your view at that point in time?
Yes.
And do we know from the record what a taxpayer, we know after the fact what Mr. Cooper's law firm's librarian got, but do we know what a taxpayer would have received upon inquiry during this relevant time frame from the city clerk?
I don't think the record's clear on that, but to the extent a taxpayer had called the city clerk and said, we saw in this notice that Ordinance 253 was adopted, could we have a copy? They would have gotten a copy.
Of the ordinance,
Of
as
the
opposed
ordinance.
to asking for the tax
And,
code.
and it's not that difficult. I think, in this day and age, we think everything's available at a push of a button, but I think those of us who've been practicing a while know that's not always been true, and particularly finding city ordinances, city laws, is not easy. I remember going down to the legislature and trying to find legislation that I knew had been passed, but hadn't hit the supplements yet. And I think reasonably knowable, which is perhaps a standard, but is something that can be looked at, does not mean easy. It does not mean at a click of a button. Even in this case, APS admits that every year they called every city they did business in to ask about condemnations so they could find out what territories were subject to tax. It wasn't necessarily hard. It required some effort, but sometimes finding the law requires some effort, particularly when you know it's happened. But even more important, if you know there's been a change and you don't read it, you shouldn't complain that you don't know the particulars.
But if you're told the change is an increase in the tax, I mean, I think it would be a stronger case if all ADOR got was, we passed an ordinance changing some things. Here it is. And then ADOR sends out the ordinance and says, it's changed some things. Here's the ordinance. But that's not what happened. The city told, as I understood it, told ADOR, we increased the tax rate from 3.5 to 4%. And this ADOR then sent out a notice without the ordinance saying they changed the tax rate from 3.5 to 4%. That's all that happened, right?
The city told ADOR everything it did because it included a copy of the ordinance.
Besides including a copy of the ordinance, though, I'm saying, but in the cover, it said, it didn't mention, the cover email did not mention the repeal of the exemption, right?
The cover email did not mention the change in tax rate.
That's
If
not what I understand.
Yeah,
What I understand from the complaint, the answer is the email attached a copy of ordinance number 253 stated that per our telephone conversation yesterday, you requested the city formulates its intent in regard to the increase of city sales tax due to the lack of evidence of advance notice to the business in the area. We assert the following. City agrees to waive collection of taxes during the 60-day waiting period. Collection shall start effective June 1st, 2008 versus April 1st, 2008, as indicated. See attached. That's what it said. And that's what I'm reading from is basically from the complaint and the answer.
Sure. And it says increase in tax, but it doesn't tell how much. The
Right.
only way
Right.
DOR could
Right.
find out the percentage or the 16 classifications it applied to is to actually read the ordinance. So DOR actually read the ordinance.
But DOR, well, we don't know that. All we know is that DOR sent out a notice that said, as I understand it, stating that effective June 1st, San Luis had increased its tax rate from 3.5 to 4%. So they read something. But
Well, they included the detail. It increases 3.5 on these 16 classifications.
Right.
That could only come from reading the ordinance. It
Right.
doesn't come from the email,
Okay.
the attachment.
Counsel,
So DOR received full information.
when you say it's and I know that you suggest that they were willfully blind to the issues of the ordinance and all that. Having some experience with small towns, if I get a letter in that says that effective such and such a date pursuant to ordinance such and such, the tax code has been changed in this regard. First off, I'm going to pay attention to what they're saying, and then I'm going to go pull the tax code. Is there any case law that says that it is the obligation of the person who has an interest in that to pull the ordinance to see that the tax code is being maintained properly or is up to date? Why do we I guess breathe why is life given to this argument based on the strength of the ordinance when the ordinance did nothing more than to modify the tax code, except that the tax code didn't reflect the change?
Well, the tax code includes the ordinances until it's codified. It's like a session law, but the legislature passed 2 months ago is not in the supplements, but it's the law if it became effective already. So the law is not just the codification. And that's part of the confusion here, that the tax code includes the amendments. You know, if San Luis had codified it and APS had asked for it and was given the wrong thing and relied on it, then we'd have a good estoppel case. But that's not what happened here. Due process doesn't require that level of detail. Due process doesn't require that the taxpayer be given individual notice, and the taxpayer does have a duty to read things that they know about.
Didn't you already tell us that we don't even know what date the change actually went into the tax code? We know it showed up there at some point, but we can't do what we do with ARS and other things and look to the date that the modification, the amendment occurred, because it's just not there. At some point the language was changed. We don't know when. So does your argument still follow?
Sure, because APS never relied on any version that San Luis officially published. APS, while they rely on due process, they're really making a notice argument, but they never did what was necessary to receive notice. They knew the ordinance had been amended. They knew that the tax law had been amended. And the tax law could be a codification, but it can be the amendments that progressively are adopted. And here, they knew it had been amended, and they didn't even read it. And the notice from DOR, while it said there's been an increase, didn't say this has been the only change in Ordinance 253. There was no representation it was the only change.
Would it have to? Is that an element of a letter sent out from DOR?
Well, I think the notices from DOR, as DOR says in their procedures, are not official, dedications of the rules. They could be wrong. And so the note from DOR tells people you can't necessarily rely on this. If it's wrong in the law controls. And so somebody reading the notice is not entitled to assume that is everything. You should go read the law. There's no secret law here. There's an ordinance number 253. It's available from the city, just like every other ordinance. Here, the legislature has essentially solved this going forward by creating rules as to what will happen, and DOR has to keep the official. The danger of the due process argument here is that will also apply to almost every type of city ordinance, county ruling, even state rules. If you can say, we didn't receive notice, or we've heard about it, but we didn't read it, I'm not sure what the limit to that is. Here, there was no official publication by San Luis that was wrong, that APS relied on. There was none, and they admit that. They admit they didn't rely on anything official from the city. And yet they knew the law had been changed, but didn't attempt to read it. I'll save the rest of my time for a vote.
Mr. Urban, before you step away, let me ask something about the jurisdictional issue.
Yeah.
And tell me if I'm right on this. My understanding is that the trial court only said that the repeal of the exemption was void. It didn't say the 3.5 to 4% was it didn't invalidate the 3.5 to 4%. Is that accurate?
That's accurate.
So if the cross appeal, or no, cross issue that's been raised, seems to say, if I understand it, seems to say you should hold the entire ordinance is invalid. And if we do that, then because of the statute, if we do that, then the 3.5% to 4% goes away. Is that right? Doesn't that and if that's right, doesn't that increase increase APS's rights?
Yes.
Okay.
They say several times in their brief, the ordinance is void and of no effect. The judgment by Judge Whitten specifically said they're entitled to an offset for certain months. But if the ordinance is void, that's a great expansion. And I actually think the Jennings case they cite supplemental actually supports this because Justice Scalia pointed out that if you make an argument with a view to expanding your rights, it's sufficient. So, Thank you.
Okay.
Mr. Cooper. And Mr. Cooper, you might want to briefly address the jurisdictional issue, because I think we do have some concerns about that.
Yes, and I think this jurisdictional issue has been resolved by the U.S. Supreme Court in the American Railway case 2 years ago, when it said preclusive effects for a potential future action do not constitute an expansion of rights. But let me address the 4% issue, because this is a complete non-issue in this case, and I'll tell you why. First of all, APS never challenged the 4% rate. So to the extent that's even a theoretical thing out there, it's been waived.
But if we hold the entire ordinance as invalid, that we can't say, we don't have jurisdiction to say the entire ordinance is invalid, except for this 3.5 to 4%. If the entire ordinance is invalid, which is what your argument is, that means the 3.5 to 4% is invalid.
Your Honor, our rights, the test is whether this alternative ground would expand rights under the judgment. All the judgment does is set aside the assessment against the APS. That is the sole. It doesn't say anything.
Right, but the 3.5 to 4% isn't part of the assessment.
That's correct. So there's nothing about this cross issue that will expand our rights under the judgment. This is a classic cross issue. What they're saying is, if
go ahead.
I'll give you trouble in your last argument. But if we had ever had an argument about the 4% increase, if there had been a challenge, if the challenge to the assessment had ever been based on it, there might be some theoretical way in which this would expand our rights. But we didn't challenge it based on that. It wasn't raised. It wasn't the subject of the assessment. In this case, the assessment in this case was not based on the 4%. It was based on the franchise fee repeal. So there's nothing about this case that has to do with the 4%, except this jurisdictional argument about it. So, Your Honor, we're not asking you to declare the ordinance unconstitutional, invalid under the statute. That has to do with this. Let me explain. If you declare, based on the alternative ground, that the ordinance is invalid,
Yes.
all that would do would have a preclusive effect in a future action that challenged the increase to 4%. Because there's nothing that affects in this case. There is no assessment based on the increase.
Right.
All it does is affect the effect of a future action. And what the Supreme Court said is that does not warrant a cross appeal.
But part of your complaint here, part of your argument, as far as in trial court, which you lost on, was that the entire ordinance is invalid because of the statute.
We didn't challenge the 4%.
But you said the entire ordinance is
It doesn't
invalid.
matter. It doesn't matter. That is
That's where you're losing me.
No, it is. What you're saying is we should have filed a cross appeal, and then we would have an objection, take a reply brief, based on the theoretical effect of our arguments in a future action, making a challenge to a different provision of an ordinance that we were not challenging in there. And what the U.S. Supreme Court said is that means every time you have raised an alternative ground, you have to file a cross appeal, even though you're not challenging the judgment. The test is, are we trying to expand our rights under this judgment? This judgment doesn't say anything about 4% or the validity of the ordinance. All it says is no assessment. That's the end of the inquiry. This is all kind of a hypothetical.
But you're appealing from the court's rejection of your argument that the ordinance was invalid.
We are defending an appeal from the judgment.
I understand that, but one of the things that you're asking us to do is say affirm the judgment, but also declare the ordinance invalid.
No, we are not seeking declaratory relief. We are seeking affirmation of the invalidation of the assessment, the setting aside assessment. That is, we are not seeking declaratory relief as to the ordinance. We did not file a cross appeal for declaratory relief, nor are we seeking for the court to say anything about the 4%. That might be a entirely different lawsuit.
You're asking us to reverse the trial judge by affirming the judgment, affirming the result. You're asking us to say the judge was wrong on the constitutionality of the statute.
No, because the judgment doesn't say anything about the constitutionality. All the judgment does is set aside the assessment. We are seeking to affirm the judgment. Leave it there. It's beautiful as it sits.
But is that consistent with what you, I mean, I'm looking at your brief. You say the tax court erred in holding that the retroactive application of SB 1331's amendments was unconstitutional. I don't see where you're limiting it in the way you're telling us.
We don't have to, Your Honor. All we have to do is say, are we trying to expand our rights under the judgment? And the judgment sets aside the assessment. The fact that...
Saying that it was unconstitutional to hold, that the court should have held that retroactive application was
valid, correct.
valid. Right. And if we say that, I understand you only want part of it, but how do we do that?
The consequences for that ruling in a future action that does involve the 4%, because this action doesn't. The whole notion that if the court were to rule on the alternative ground, it might affect something else out there that's not this judgment. That is exactly what the Supreme Court was talking about in Jennings versus Stevens. That doesn't require it. That's for another lawsuit.
But would you agree with me that the a final judgment incorporates all the interlocutory orders that led up to it?
That's correct, but well, that's for appealability. But the terms of the final judgment is setting aside the assessment. That is the relief we are granted, and that's the relief we're seeking to affirm.
So, in essence, if we ruled in your favor on the due process issue, the notice issue, you would walk away a very happy man.
Yes, absolutely. Absolutely. We're seeking to affirm the ruling. But we think that the ruling, that the invalidation of the Arizona statute is a serious problem, particularly because it's an incorrect ruling as a matter of law. The one theme that connects all of these issues is, in Arizona, since 1988, we do not allow municipalities to tax by straight ordinance. The legislature made a decision to move to a codified system. It's the code that matters. So what do we know here? We know that they passed it, they didn't report it to the Municipal Tax Code Commission, and I have to correct Mr. Urban. We know a couple of more things. First of all, he said everything's available at a push of a button. To this day, the city of San Luis puts its entire city code on the web, but not the tax code. Okay, so it's not available.
I think he said most things aren't. It's not. You can't just
well.
Necessarily get
This is the one exception in the city of San Luis, and he said a time lag. Well, this is a serious time lag because when we did, this is not an estoppel case. It's not about reliance. It has to be whether this was put out there and reasonably knowable by anybody. And what we know is that when we did ask the city, 4 years, in 2012, we got a copy called 2011 edition that showed the 4% change. It showed subsequent ordinances to 2011, but it still didn't show the change in the offset.
When you received a copy of what in 2000?
The tax code. We made a public records request to the city of San Luis, and what we got was a 2011 edition that didn't show the repeal in 2007. It showed later changes, but not that one. And since at that point we were in litigation with the city, the next day we get a copy from the city attorney saying, oh, here's another version that shows the change. They sent you the wrong one, with no explanation of why you're supposed to be able to rely on the city clerk. The clerk sends us one. The city attorney sends us a new version
of the tax code.
Of the tax code.
That incorporates
but the 2011 edition that we got from the town in response to the request did not show that particular change.
And the one that the city attorney sent you?
The city one did show it. And so
was the 2011 version?
Well, I think it's called 2011 version. It's getting very strange here. Because then, when the tax court pointedly asked counsel, is there any evidence that the clerk's office had a copy of the code in 2000, even through 2012 that showed the change? And counsel had to admit, we cited in our brief, that they couldn't point to anything in the record. So then we get an affidavit after the hearing from Katie St. Louis, who's not the town clerk, she's the finance director. From the town clerk saying, well, the finance director in 2012 sent a copy that showed all the changes, and I believe the language was something like, the version sent by Ms. St. Louis to the department was in the possession of this office at the time it was sent. That could mean it's in somebody's Outlook folder, attached to the email that was transmitting it to the department, and that's 2012. What we know is that when we did ask the clerk, in a public records request, we got a version marked 2011 that didn't show the change, even though it showed all the later changes that had been made to the code and the 4% change. So if you want to talk about time lag, anyone looking at that code would think that all changes had been made. And that's the whole point of the system.
But what about, you said the legislature as of 1988 said, you can't do this by stray ordinance, you have to do it by tax code.
That's why it created the Model Cities tax code. That's correct.
Is there a specific reference for that, a specific authority
Well,
for that?
I think the evidence that's been put in, that's detailed in the brief, shows that was the whole scheme of this. But I think what you need to know
Can you, but can you point me to something that says, in the legislative, in the statutes, that says, you can't do this by stray ordinance, it's got to be incorporated in the tax code to be effective?
But that's what happened in 2014 when the legislature came back and exercised its plenary authority over municipalities to codify the way the system had worked. Okay. That is, the Model C.
Right, but there was no specific statute you can point to say that prior to 2014, an ordinance wasn't good enough, it had to be in the tax code.
Well, that is the way the system worked, maybe not by statute, but by, the League of Arizona Cities and Towns was the drafter with the participation of taxpayers of the model code, and the legislature indicates that the Model C tax code was what was submitted, and that's what the statutes were, and there was reporting requirements if you wanted to make changes. So what happens is the legislature comes back and says in 2014, we see what happened in the city of San Luis, we see what happened in the town of Florence, and so this is not the way it's supposed to happen. So they go back and fix it from the beginning and saying you had to report it and it had to be codified in the official version.
What?
Because that's the way it was supposed to work. And that's the way apparently it had to work, except for some outlier municipalities that weren't getting it done.
So what about Mr. Irvin's argument that says you had notice that an ordinance passed? Why didn't you look at it?
If we had there were a lot of ordinances that got passed by all the 91 cities and towns in Arizona. So the notion was you're told an ordinance has been passed. So if it had been an ordinance dealing with signage, would we have said, well, who knows there could have been something by tax in there?
But you knew more than that. You knew from the ADOR communication that it dealt specifically with something that interested APS. And so as opposed to your experience with the tax code, what do we have in the record that shows APS made any attempt to obtain Ordinance 253 to read it itself?
APS didn't have to. This is not a reliance issue. This has to do, and it frankly doesn't turn on the department's notice. It has to do with the fact that there was no publicly available copy of the code through the audit period that showed that this change had been made.
I understand the code. I understand your argument about the code, but I'm getting back to Mr. Irvin's argument that reasonably knowable may be a little broader concept. We know that APS knew about 253. We know that APS knew it affected them in some substantial way, but we don't know what, if any, efforts it made to obtain the ordinance, correct?
APS is a large taxpayer. APS relied on the notice from the department.
I thought you said it wasn't a reliance issue.
Well, I'm not saying that they relied. It's not. You're asking as a matter of fact. Our legal argument doesn't turn on reliance.
Okay.
Our argument turns on the fact that the city didn't amend their code. And this isn't about a time lag, because when you did look at their code in 2011 edition, it showed all the subsequent changes, and it didn't show that change from.
Let's get back to this idea factually. Is there any evidence that, I think there was some evidence, and I can't put my finger on it, but that APS actually had an employee that was dedicated to sort of reviewing changes in tax codes?
Well, they have employees who look.
Right.
But taxpayers shouldn't have to, and it's rare to find one that does.
I understand your argument, but I'm just saying, so they had this person, and ADOR sends out a notice that says, hey, this ordinance was passed. It raises the tax rate.
Right.
Is there any evidence that APS then contacted ADOR and said, not that whether they should have, but is there any evidence, anything in the record that says ADOR did or did not then ask ADOR, can you send me a copy of this ordinance?
I don't believe that fact is in the record.
Okay.
Would that be standard operating procedure?
Again, I'd have to go outside of the record to say what the standard operating procedure. I can't answer based on my speculation about what the standard operating procedure, if it's outside the record.
As you have pointed out, there are 91 municipalities
Right.
in the state. I think the briefs say that APS serves over 50 of those 91. What typically happens in these cases? What does APS typically do when they get notice that an ordinance 253 has passed?
Again, the fact that a town has passed an ordinance, it depends what the information is. You can't keep track of all the ordinances, even ordinances that deal with tax. It may be, for example, an ordinance that deals with tax, but doesn't deal with an issue that involves APS. But the notion that because you know there's a word tax out there, you have to start reading every ordinance, even if it has something to do with a completely different subject. I can't answer what they would do if they got an ordinance that said X.
I want to tie down one point to follow up on Judge Kessler's. His specific question was there anything in the record that reflected that after being advised that by ADOR of 253 that your client asked ADOR for the ordinance, and your answer was there's nothing in the record.
I don't believe
I want to
there is.
ask the same question. Is there anything in the record that reflects that APS asked the city clerk for a copy of ordinance 253?
I don't believe there is.
Until 2012.
That was the tax code, though.
When they asked for a copy of the code.
The tax code.
When they asked for a copy of the code. But I'm going to go back to the
Anything,
stat.
let me
Okay.
follow on that one last thing. Is there anything in the record that reflects that at any point APS was put on notice that 253 included anything more than the graduated increase from 3.5 to 4.4?
That is exactly the correct point, Your Honor. The answer is no. No one said anything. And it's funny that when the tax code, they put out their 2011 version of the City of San Luis tax code, it made the 4% change, which was consistent with what the information was out there. But it didn't make the change as to the franchise fee offset. There was no notice anywhere to anyone that there was this other provision in the ordinance that would have said to anyone who cared about franchise fee offsets. And it should be noted that APS is the only party in San Luis that pays, that was able to take advantage of that franchise fee tax credit, that it should have known to go look for that. All it was put on notice was a change in the percentage rate of the taxes.
Just for planning, I'm going to ask our bailiff to add 2 minutes to each side because Judge Kessler wants to prolong his last argument.
Okay. I appreciate that.
Only if we need to.
I appreciate
Don't feel
going out
obligated
with
to
Judge
use
You
Kessler.
don't
all
have to use the time. But
I know.
Yeah,
Well, I want to talk about the statutory argument because I think the waiver issue is incorrect. There are lots of occasions where people are trying to defend judgments on alternative grounds, when the alternative grounds will change what may happen in a future case, whether it's preclusion, whether it's the invalidation. There is no challenge to the 4% rate. APS paid it. The APS didn't try to seek a refund based on the invalidation of it. The U.S. Supreme Court had said, based on the American Railway Express case, which was the foundation of Arizona's rule on cross appeals, that worrying about the hypothetical effect in future cases is not what the cross appeal rule is about. It's, are you trying to get something more in this case under the judgment? And the answer is we're not. We love the judgment. We helped draft the judgment. The judgment's fine. All we want the court to do is affirm it. The more logical ground to affirm it on is the statutory ground of it, is the statutory basis, because we have a valid Arizona statute, and the Court of Appeal and the tax court invalidated it erroneously based on its application to a closed class retroactively. We submit that that was incorrect because, as the New Jersey court noted in Clark versus Bine, all retroactively applied statutes affect the closed class. That's the nature of it being closed. The Arizona Court of Appeals said in Fund Manager that, you don't analyze retroactive effect differently from prospective effect. You look at them all together, and as long as this is going to apply broadly in the future, the fact it applies to a limited number of people in the past doesn't make a difference. And with all respect to the city of San Luis, their reply brief is incorrect. The fund manager didn't say it had to apply in exactly the same way. It just noted that the particular statute had applied the same way. The only difference they point to is that there was a limited refund provision that protects cities. They're not aggrieved by this. That's why they can't bring in equal protection. The limited refund provision protects cities by saying, you know what, we're not going to let you, do more improper taxation, but we are not going to make you come out of pocket as the past. So the notion that somehow that strikes down, that makes this a special law simply because all the cities that are retroactively affected may not have to come out of pocket for past taxes collected, doesn't make it a special law. It still applies the same mandates as to codification, as to reporting, apply to both the past and to the future. And that's why it's not a special law. The notion that also that we singled out the city of San Luis, or the legislature singled out the city of San Luis, and they're the only ones being affected by retroactivity. They know that's not true. If you look at pages 43 to 46 of our brief, they were running around the city of San Luis, quoting Mr. Irvin, like Chicken Little, telling all the other cities and towns, and putting it on listservs that retroactivity was going to hit all of them really hard. They all should start scurrying to figure out if they had assessments or statutes, ordinances that were going to be affected by this. So they knew it wasn't. The legislature knew it wasn't because it's looked at the special law issue and said, no, we know there's a problem with Florence, and so this is a more general. It's not just about the city of San Luis. Their argument for why this is a special law really amounts to an ad hominem attack on APS. But any taxpayer would want to be assured that changes to the code are reported and codified, and this is a generally applicable statute. Again, all we are seeking is to affirm the judgment below. To the extent that there was a challenge to a 4% rate, that's been waived a long time ago. That was never had any part of this lawsuit. It's not part of the judgment. It was not part of the assessment. I think it's frankly a red herring. And there was no reason for us to file a notice of cross appeal in order to affirm an existing judgment based on what might happen in a hypothetical case. The Supreme Court has put a lie to that theory of cross appeals. I see my time is up, so unless Judge Kessler wants to expand this even further, I'm happy to do this as always. But
both of you have already made my day. Thank you.
With that, I take my seat.
Proving state tax issues are sometimes the most interesting issues, particularly to go out on. But in terms of...
We'll quote you on that, counsel.
Very good. It's on video. The one thing clarified, the record is actually clear that APS did not consult the San Luis tax code on file in the city clerk's office until after the audit period in 2013, and that's in Index of the Record 77, page 12, note 10.
Counsel, if I may, why do we have the one element of the ordinance incorporated in? You were talking about the codification of an ordinance change in the tax code. Why do we have the one aspect in the tax code, the 3.5 to 4, but not the other aspect that we're debating here? Why was that?
We don't know. It was just a mistake. And the thing is, under the cases even that APS cites, mistakes to create due process issues have to be in official publications that people rely on.
Well, wouldn't that be an official publication where something was not included that should have been included, so it would have put APS on notice?
Well, it was almost a year after the audit period ended, so it certainly wasn't anything they relied on here. And it was corrected the very next day.
Right, but the city clerk sent it out, right?
Well, the city clerk sent it out. The city attorney responded yesterday, and as the declaration and the affidavit in the record shows, the city attorney was acting for the city clerk. And the city clerk said, we had the right version in our office. We had the right, correct, complete codification in our office that day. The wrong version was sent out. We had the correct, complete version in our office on July 3rd, 2012, which is what we sent to the Department of Revenue. But nobody read that.
Okay.
APS never claims to have asked. And that's why they have to essentially invent a test for publicly available. The cases they cite never talk about publicly available. They talk about official publications, published with authority. Here, the only official publication would have been something that the city of San Luis gave to APS. They could have asked. The record is clear that they contacted cities, all the cities they did business in every year to ask about annexations. It's not that hard to call and ask about an ordinance. They could have gotten the ordinance. If they got the wrong ordinance, then we'd have a different issue. because we'd have a clear estoppel issue, which is based on reliance. They know that's not true here, so they push on the due process based on publicly available, which is not in any test. The reality is, until 2012, there was no official updated version of the Model City Tax Code that taxpayers could rely on. That's why the legislature changed the law effective in 2012, because relying on the league version wasn't working. It was not something people could rely on. There were errors. It was wrong. The law changed in 2012. During this audit period, there was no official version that was updated regularly. The law was the city tax law, which included the code, but also the amendments, including the ordinance. But most importantly, and amazingly, they argue we had no obligation to look, we had no obligation to read, we had no obligation to look out for our interest, even though we knew the code in a city where we did business had been amended. And standard operating procedure for me, if I read something and think it applies to me, is I go and read the original sources. I don't rely on third-party publications, third-party summaries. And if that is the law, you're going to get a lot more cases, not Judge Kessler, but the rest of the court will. Thank you very much.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course, and at this time, the court stands adjourned.